You'd think the mission in healthcare would be pretty simple, right? Just protect the patient's well-being. But what happens when that mission turns into a maze? When there are conflicting duties and the right path forward is anything but clear? Well, let's try to untangle that.
And this right here is the question at the very heart of it all. This is the dilemma that psychiatric professionals live with. It's this constant, high-stakes tightrope walk between a patient's absolute right to privacy and the fundamental need to keep the public safe.
So to navigate this, every psychiatric mental health nurse practitioner, or PMHNP for short, relies on two different guides. And as you're about to see, these two guides, well, they don't always point in the same direction. Okay, here's a good way to think about it. Imagine you're driving a car. The law, that's what you see on the right, that's the speed limit. It is the absolute bare minimum standard you must follow to avoid getting a ticket. But ethics, over on the left, that's about being a good, courteous driver. You know, letting someone merge, looking out for others on the road. It's what you should do. One is a mandatory requirement, and the other is an aspirational ideal. And just so we're all on the same page, when we say PMHNP, this is who we're talking about. These are highly trained, advanced practice nurses. They're the professionals on the front lines of these incredibly complex situations, making these tough judgment calls every single day. All right, let's move away from the theory and jump into a very real, very high-stakes scenario. This is exactly where those ideals and those rules can collide with some serious force. And it all revolves around something called the duty to warn. I mean, just imagine you're the clinician and you hear that. That's the conflict in a nutshell, isn't it? You've built trust with this patient. You have a professional duty to keep their information confidential. But now, all of a sudden, that duty is in a head-on collision with a duty to protect someone from harm. So what do you do? This is the duty to warn. The idea was really cemented by a landmark case back in 1976 called Tarasoff v. Regents of the University of California. It's the official term for a professional's obligation to break confidentiality when there's a serious, credible, and specific threat. You know, it's one of those rare moments where breaking a patient's trust isn't just an option, it's actually legally and ethically required. But of course, just when you think you have a handle on it, it gets more complicated. Applying this duty to warn isn't a one-size-fits-all kind of thing. The rules for things like confidentiality and consent, they change, and they change dramatically, depending on whether your patient is an adult or a child. See, for an adult patient, confidentiality is king. It's legally protected with very, very few exceptions. They provide their own consent for treatment. But with a child or an adolescent, the whole game changes. Their confidentiality is limited because parents and guardians have legal rights to their information. And while a kid might agree to treatment, we call that assent, it's the guardian who provides the actual legal consent. So you can see how the path for the practitioner is way more complex when treating a minor. It's not just about the patient and a potential victim anymore. Now you've got guardians and mandatory child safety reporting laws in the mix. So with all these overlapping duties and rules and different stakeholders, how does a practitioner ever make the right call? Well, you'll be glad to know they don't just guess. They use a very structured, deliberate framework to make sure their decisions are as ethically and legally sound as possible. Here's kind of what that playbook looks like. Step 1, they have to identify the dilemma. Is this a real, credible, specific threat, or just someone blowing off steam? Step 2, they consult their ethical codes. What do the highest ideals of their profession say they should do here? Step 3, they have to review state law. What does the law say they must do in this exact situation? And finally, after weighing all of that, step 4 is to act to protect, taking whatever steps are necessary to keep people safe. It's a very methodical process, not some gut reaction. And at the end of the day, that's the key takeaway. It is never about choosing ethics or law. It's about finding that precise, careful balance between the two. The entire system is designed to uphold the duty to care for the individual patient while also upholding the duty to protect the community. It's about protecting both. And that leaves us with a final, pretty big question, doesn't it? This balancing act. It's not just something a clinician does alone in their office. It's something we as a whole society have to constantly think about and reevaluate. There's really no simple answer, but understanding the framework, well, it helps us appreciate the incredible responsibility we place on these professionals every single day.